right. I hope everyone can hear me. And please just put on chat if you cannot. I hope you can. Okay. Good morning, afternoon, or evening from wherever you are tuning in. Welcome, participants, respected judges, and the organising team to the training session of MediateGuru's first virtual international negotiation competition, hosted by the Newcastle University of the UK and supported by L&L Partners. I am Aviva, and I will be the moderator for this session. Before we begin, please do remember all the resources have been sent out. Please go through them carefully, and you can ask any query at the end of the session. Now, it's time we introduced the eminent speakers for the training session. Our first trainer for this session is Ms. Sasha Matar. Ms. Sasha Matar is a Lebanese journalist and editor. She practiced law for a year and then decided to explore other areas that would help her in becoming the analyst she is today. Ms. Matar believes that the law is shaped by social norms, politics, and economy. Thus, she decided to explore further those areas through practice and research. Ms. Matar comes from diverse disciplines. She graduated with a bachelor in law from the Lebanese University and is currently pursuing her master's degree in political science with a minor in international organizations. She participated in and judged multiple moot courts and helped organize some of them in her country of origin. Aside from her legal and political background, she is a conflict resolution coach. Ms. Matar received her coaching training at Coach Transformation Academy in Dubai. She is a geopolitical, economic, and financial researcher and analyst. She is an aspiring mediator and has helped establish the Lebanese chapter of MediateGuru that has brought awareness to mediation in multiple law schools across Lebanon through ambassadors like the Lebanese University, USIC, the Islamic University of Lebanon, Beirut Arab University, and Jamiatul Hikmi, also known as Lesseges University. Now, let us take, okay, over to you, Ms. Matar.
Thank you, Aviva. I hope everyone's doing well. I'm going to start by sharing the presentation. Up. No, give me 1 second. Up. I hope I'm audible and you can hear me well without the background noise that I have around me.
Yes, I think we can perfectly hear you.
All right. Okay, so what I will be doing during this presentation is basically I'm going to go through the rules and regulations for this competition. And there it is. Okay, so can you see it on the screen, Aviva? Is it clear? All right. So first of all, well, congratulations for making it here, for getting qualified. And I hope you have all submitted your negotiation plans. And if you haven't yet, please go check your mailboxes if the emails have been sent, or if you have perhaps forgot to attach your plan with the email or anything of that kind. Just make sure that it is sent. But basically, if you're here, you're qualified to continue through the preliminary rounds of the competition. So, to start with the presentation and with the content of this current session. This is the first, as you may all know, this is the first virtual international negotiation competition that MediateGuru organizes with Newcastle University and L&L partner firm. It aims to improve the negotiation skills of the participants, as you can see in front of you, and it's a opportunity for all of you to learn from peers who are expert in this, who are expert in the negotiation area, not only from peers, but also peers who have basically participated previously in such mediation or negotiation competition. If it's your first time participating in such negotiation competition or mediation competition, do not be afraid of it. This is the opportunity basically for you to learn. And if you don't go further in the competition, that's also never a problem. It's an opportunity to learn and to learn some basic skills to use in future competition, because this is not going to be the first and last one. There's going to be definitely future collaboration with MediateGuru on an international level that everyone can participate on. And of course, you will get to benefit from the expertise of the judges who will be assessing your skills and helping you understand where to push forward and what's the weaknesses that you should be basically working on. Of course, the judges will all be giving you positive feedbacks that will help you in understanding where you should evolve. So, and finally, this is, of course, an international setup where you will get to meet and be introduced to peers from all over the world, which is basically an opportunity for you to learn from different cultures. I remember myself, who participated in multiple international moot courts, whether legal or in moot or courts, in competition related to negotiation or mediation. I have met several people from all over the world with whom I have kept contact and I am very close friends with until the moment, even after graduating from law school. So I'm going to go through some definitions right now, some basic definitions to the terms that you will see a lot during the competition. First of all, when we say organizers, basically the organizers of this competitions are the team of MediateGuru, and the host partner in this competition is Newcastle University, as you may all know, and the participants are yourselves or the qualified teams that have been invited to participate in the preliminary rounds, and of course the venue, which has been in the beginning, it was set to be in a hybrid setup, but since there was no opportunity for people to come to India, so then the organizers decided to keep it as an online platform. They keep the competition happening in an online platform. So the team basically of the participants, every team participating has to be composed of 2 individuals. One student will be taking part as a counsel and the other taking part as a client, and both of you should be changing roles in the preliminary round. So in the preliminary round, the first one, the counsel will become a client in the second one, and vice versa. The team is responsible for interpreting the facts and draw conclusions. Of course, the interpretation and the conclusions will have to be reasonable and within the limits of the facts of the problems, the negotiation problems that have been sent to you. So it's very important for you to avoid creating new facts and drawing conclusions and interpretations that are in no way related to the facts of the problems. And if you have done so, it will be within the discretion of the judges to assess whether those facts or those interpretations are in any way related to the negotiation problem. The participants as well must all time during the negotiation session, they don't have to disclose the names of the teams and the members, the coaches, the institutions, or any country they come from to the judges. So this is very important, because this would be penalized, and this would perhaps mean that you will be disqualified from the session, from the competition. Of course, this will be assessed by the organizers of the competition. It's just for you to understand, if you haven't gone through all the rules and regulation of the competition, the preliminary rounds will be around 45 minutes, 35 minutes of which will be dedicated for the negotiation, and the rest of the time will be dedicated for the judges to give their scoring and their feedback to the teams. And of course, it will in this setup, 2.5 minutes will be given to one participant, and the rest of the time will be given to the other participant, as per the judge's discretion, of course. So make sure to make good use of this time and to avoid exceeding this time, because then you will lose time from understanding where are your weaknesses and in which areas you should be improving. And most importantly, why you should be using this time as allocated, because I've participated in assessing several negotiation or mediation competition, and I have seen a lot of teams sometimes exceeding this limited time, and it has sometimes made the judges, or we have always been tolerant, of course, but this could always mean that the judges can stop you from continuing your reasoning or whatever that you're trying to say. So always try to be concise with the words, have your ideas prepared very well before starting the session. Of course, you might be faced with some new facts, you might be faced with with some new information coming from the opposing participants, and this is something that you need to be prepared on. This is one of the most important things that these competitions teach you: how to face new challenges, how to reply to new facts or new deliverables from the opposing party in front of you. And as you can see, for the rest of the semi-final round will be around 50 minutes, not around, but it will be 50 minutes, and the final will be 80 minutes. As per the negotiation plan, I'm pretty sure by now that all of you, I hope, have already submitted the negotiation plan to the organizers that are being currently assessed by the judges. The negotiation plan, you have to understand that it's basically a training for you. It is not scored. However, it will be assessed in order just to know to whom the organizers will award the best negotiation plan award. And when will the result or the assessment of the negotiation plan be used? In case there was a tie in the score, then the negotiation plan will determine whether you will advance or not. And we will discuss this in a bit. The hierarchy of the assessment of the scores in case there was a tie in the score. In regards to the ranking and the qualification, so of course, the teams with the higher number of points on a judge's score sheet will be winners on that same judge's score sheet. So the judges will mark the team, both teams, with this, not an equal score. I'm sorry, this is a mistake here, not equal score, but they will mark the teams with a score, and the winning, both teams, the team that has got most points will be winner in regards to this judge's scoring. The overall win-win or win-lose or win-win will mean that will determine whether this team will advance or will not advance, and this will depend also on the scoring that the judge will put in regards to the criteria, which we will go through in a bit. I will go through with you all the judging criteria, and please take note when it comes to this point, because this will be very important for you. I mean, you still have time if you've got some time tonight to review your plan and review perhaps also the way that you're going to deliver. If you see that these criteria match with your plan and with what you're planning to deliver tomorrow, that's great. If not, try to do as fast as possible the changes so you will have better chances in advancing in the competition. In order to qualify to the semi-final rounds, the total number of overall points will be calculated that you have earned in the preliminary rounds 1 and 2. Of course, the top 4 ranked teams will advance from preliminary rounds to the semi-final rounds. And this is a very tough competition because there are 66 teams that have been qualified. So best of luck to all of you. Of course, not all of you will be winners, but take this as an opportunity to learn. And who knows, maybe if not this time, it's going to be next time. Just consider this a learning opportunity rather than just having an award at the end of this session. And of course, 2 teams will advance from semi-final rounds to the final round, and then there will be 1 winner at the end. One, let's say figuratively, winner, and the winner of this competition. Consider yourselves all winners because you have learned a lot by preparing, delivering, and learning from the judges as well, from their feedbacks to you. So as I have mentioned previously to you, this is the hierarchy of how your scores will be considered. You will be qualified to the next rounds from preliminary rounds to semifinals, or from semifinals to final, according to the total number total number of your score that will designate if you will go to the next round or not. And if in case there was 2 teams who have the same number of who have scored the same number, then we will consider the overall round in order to see whether you will go to the semifinal or not. So you will be considered. I'm sorry. Your scores from preliminary round 1 and preliminary round 2 will determine whether you go to the semifinal. And if there will still be a tie, then we will go to the scores you have been given on the according to the negotiation plan, which I have previously mentioned to you. I see Anna, who has joined us. Hi.
Hello,
I will be
everyone.
finishing the presentation, and then we will give the floor to you, okay?
It's okay. Take your time.
Thank you. Those are the judging criteria, which I was telling you previously about, and I hope that you will be taking notes here. You will be, first of all, assessed according to the planning and analysis that you have made before entering the session. So the planning and the analysis that you have prepared pre-competition, and you will be assessed on regarding how you have performed and what are the strategies you have used, and so on. Second of all, your flexibility and adaptation skills will be assessed as well. So in this regard, the team will be assessed if it was able to adapt to the strategies and the new information delivered by the other team. Third of all, you will be assessed on the outcome you have delivered, regardless of whether there was an agreement reached at the end of the session or not. So don't be very stressed to reach an agreement, but rather make sure the strategies and the flexibility that you have, that you can illustrate during the session, attract the judges. You will also be assessed on of course, the teamwork that you will show, This means, have the team members worked together? Have they shared responsibility? Have they communicated? Have they provided mutual support to one another? This is very important. And finally, which goes without saying, teamwork skills with your opposing team as well. So this is, the opposing team is not our enemy. The team should demonstrate the team should always be contributing with the opposing team to the goals of the client. So you should make sure not to detract from achieving the client's best interest. This is what's mostly important here. So those are the judging criteria. When would you get disqualified? In which cases? If you fail to submit the negotiation plan in accordance with the competition rules, and I'm pretty sure by now, and I hope that you have all submitted your negotiation plan. If you fail to comply to the dress code, so please make sure that you are always in a formal wear throughout the competition duration. I mean, if you finish your negotiation, the time allocated for your negotiation, don't go change your clause, because if you are called after that to participate in the award distribution and all of that, you will also be obliged to be in a formal dress. Okay? And finally, if you do not comply with these rules and all what has been transmitted, what was communicated to you throughout the past 26 minutes since we have started this session, you will be disqualified. Of course, this is to be taken, everything will be taken into consideration by the organizing team. Everything that will be fair, their assessment will be fair, and the disqualification will not be directly communicated to you. It will be communicated to you, but it will also be communicated to your university. So be very responsible in this area. What could be your penalties? You may be penalized in case you fail to adhere to time limits. This is a little bit perhaps exaggerated. This will be taken into consideration on a case-by-case, but make sure that you adhere to time limits. And if you fail to stay within a reasonable interpretation of the negotiation simulation, you will also be penalized. But those two things are very easy not to fail in doing. So I don't think anyone who is present with us today will be failing in any of these. The awards are as follow. Everyone will be receiving a certification of participation. There will be an award given to the best negotiation pair and to the second best negotiation pair. There will be also an award given to the best negotiation pair in prelims and an award given to the best negotiation plan. Some little diverse rules and information to take into consideration throughout the competition. If one of the team members is notified of any particular information related to the administration part of the competition, will mean that both of team members are informed. So make sure to communicate among one another and to tell each other whatever updates you have. Always pay attention that the time that is in front of you refers to the Indian Standard Time. So make sure to convert always the time to your local standard time in order to avoid not appearing in front of your team member, your opposing team. Of course, we have previously mentioned this, that you have to be in a formal wear. And the administrators may blacklist a team from participating in future editions of the competition, but this is basically a very severe measure to be taken unless something very absurd has happened. The organizers may take other measures as they deem fit for the orderly and fair conduct of the competition. And this is the last point in here is very, very important. If any team on their allotted time does not appear, the opposing team will get their scores double in their previous or upcoming round. And this is called a walkover. So the walkover clause is very, very important. So if you fail to appear in your allotted time, you will be giving the opposing team in front of you double their score, whether in the coming session or coming round or the previous round. For example, this is stated in the rules and regulations that have been communicated to you. If in the preliminary round 1, let's say team VIC 1, 2, 3 did not appear in front of team VIC team 1, 2, 4, this will mean that team VIC 1, 2, 4 will get a walkover, and their scores of the preliminary round 2 would be double to compensate for the first round. All right, unless you are doing this on a pro bono basis and you are very charitable and you want to give the double scores for your opposing team members, do that. If you do not want to do that, then just don't do it. Aviva, is there anything that you wanted to say? I felt like you wanted to say something. No? Okay. All right. So I think this is briefly everything that you should be taking into consideration throughout the session. I will be taking some questions right now. So Aviva, if you think there are anything that has been communicated in the chat box, please let me know. Aviva, I can't hear you. I think you're on mute.
Apologies. Can you hear me now?
Yeah.
Right. We have actually some questions from the audience.
All right.
By the way, thank you for this amazing tutorial.
Thank you.
So we have a question from Zachary and Bradley. It says, I was under the impression that it went points and then wins if a tie, as stated in the criteria. Is this not correct?
Can you repeat the question?
So I was under the impression that it went points and then wins if a tie, as stated in the criteria.
Points and then wins. Let me just go back to. So the points that you will get, let's say in preliminary round 1 and preliminary round 2, will determine your position in where you will be standing in regards to other teams that are competing with you. So the 4 teams with the best scores will move to the second round. Will move to, let's say, from preliminary rounds to semi-final round. However, in preliminary round 1, let's say you and I, Aviva, are right now in the competition. If I get more scores than you do right now, this will mean I will be qualified and you will be disqualified, or vice versa, let's say. Okay? So if you are disqualified in this round, and not disqualified, I mean, if you're still in preliminary round 1, we still have preliminary round 2. So if in the preliminary round 2 you still do not I'm sorry, okay, I got lost a little bit. Let's go back. I get or you got more scores than I did in preliminary round 1. This means that I won this preliminary round 1. However, if you got more scores than I did in preliminary round 2, and your score is like, you go, let's say you're now number 6 in the positions of all among all the teams. This will mean if you are 6 and I am 7, you are more qualified to go to the semi-final rounds than I am. But if you and I have the same score, and in the first round you got a win, and I did not get a win, you will be more qualified than I am. So let's say you have a 50, I have a 50. In the first round, you were the winner, and in the second round, you lost. But in the first round, I was a win, and in the second round, I was a win. I'm qualified. So if we both 50, you got one win, and I got 2 wins, I get the opportunity to go to the semi-final round, not you. I hope this is clear. I know I got you a little bit lost, but I got lost all the way through it. But I hope it's clear now.
I think it is perfectly clear, Ms. Matar. So I go on to read the second question. Only 4 teams will be selected from a preliminary session. Is that correct?
Correct.
Great. And then we have another question from Kushi. Do you have it? Do you have to change the file in other preliminary rounds?
Do we have to change the file in other preliminary round? Could you please clarify this question? Kushi, if you could clarify this question, that would be awesome. I mean, because I think it's too vague.
Oh, she meant role. I was notified rather than file. So do we have to change the roles in other preliminary rounds?
Yeah, if in the first round you're client, in the second one you have to be counsel, and vice versa.
Switching the roles, yes. Thank you. And we have another question from Carly. Do I need to read out VINC or just a number behind it?
Your name will be VINC, etc. So
VINC.
If you think that within the setup of the room that you are in, you have enough time to say VINC 1, 2, 3, go ahead and say it. If not, it goes without saying. It's by default VINC. Your team name starts with VINC. We all know that. Just go ahead and say 1, 2, 3, or whatever the number of your team is.
Thank you. And the next question is, if a team walks off in both the preliminary rounds, how can the present opposing team be able to proceed to the quarterfinals?
Yes, I went through this. If I walk out on you, let's say, this will mean that you will have your scores doubled. Let's say if you go to preliminary, you're gonna go to preliminary round 2. So if I walk out on you on first round, the score that you get in the second round will be doubled. And if I walk out on you on the second round, the score that you got on the first round will be doubled.
Yes, I think this makes perfectly clear. Thank you very much, Ms. Matar. This was an inspiring and vibrant session.
All right, perfect. Thank you, Aviva, for conducting and moderating this session. I think that was all the questions, right? All the questions were covered.
Oh, well, I was actually, yes.
Okay, perfect. I'm just gonna wish all of you best of luck, and I think I will see you on the last day of the competition in the distribution of the award. I wish you all best of luck, and I think now I'm gonna give the floor back to you, Aviva, and to Anna. I think.
Thank you. Lovely.
Okay.
Thanks very much indeed.
Thank you. Bye bye.
Have a good day. So, welcome, Anna Sambold.
Hello.
Hello. How are you?
Could we try to share my PowerPoint?
Of course.
Thank you. Okay, so let's try it.
In the meantime, can I introduce you?
The thing is, I have a slide with my bio a little bit, so I wanted to display while you were introducing me. But I guess this is the previous PowerPoint on on file. So it's how I can find mine.
Right. Let me consult my teammates.
Yeah. This is the thing. Webinar is a pretty new thing to me. I use normally Zoom. No webinar, Jam.
It says here that if you can click on add a new presentation on a green box.
On the green box.
Yes, just below start presentation or add a new presentation, it says here on the right hand side of the page.
I don't see the add new presentation. Did you see it?
We do not see that.
I see the slides, and I see on the right, I see the PowerPoint and the previous PowerPoint.
Yes, click on the slides option first in menu. If you can go to slides option.
Okay.
Did you manage?
Yeah, but
did you
give me to add anything?
Okay. So can we redo it, perhaps, if we can? Okay,
cancel.
It says type.
Now it gives me the option. Thank you.
That's great.
Name. Oh gosh. This is pretty new. And it's so funny because this is one of the tips that I was planning to share with the students. I was planning to say, you have to be sure that the technology works. Because this is one of the things that can happen during the competition. And there we go. This is a good example. There you go. Oh, they had to upload the presentation to the system. But in the meantime, I guess we can go ahead introducing me. This is taking 2 minutes.
Okay, right.
Thank you.
Thank you. So everyone, our next trainer is Miss Anna Sambold. Professor Sambold is one of the United States' leading alternative dispute resolution professionals. She's a California-based attorney, mediator, arbitrator, and negotiation professor with over a decade of experience as a conflict resolution specialist. She has served as a neutral in over 1,000 cases across a broad spectrum of civil litigation matters involving commercial, insurance, property, employment, cross-cultural, multinational, and multilingual parties. Ms. Sambold is an International Mediation Institute certified mediator, National Academy of Distinguished Neutrals, and International Arbitral Women. She is also on the neutral panels of several ADR providers, the US courts, federal and state agencies. As an unstoppable advocate for ADR, Ms. Sambold has greatly contributed to the promotion of dispute resolution alternatives and the effective and collaborative resolution of disputes worldwide. As an outstanding and proven leader in the legal and ADR field, she currently serves as the American Bar Association Dispute Resolution Section Vice Chair, Advanced Mediation and Advocacy Skills Institute Co-Chair, San Diego County Bar Association ADR Section Chair, and San Diego Law Library Foundation President. She's the immediate past co-chair of the California Lawyers Association Litigation Section, ADR Committee, and she has also served as a member of the board of directors of the Chartered Institute of Arbitrators, North American branch, and the Southern California Mediation Association. Ms. Sambold currently serves as a negotiation professor at University of San Diego School of Law. She has also taught at California Western Law School International LLM program and with the National Conflict Resolution Center. She is a frequent speaker on ADR topics in Europe, in Asia, and the Americas. She received her Master of Laws from the University of San Diego School of Law, her training as well as credentials in dispute resolution from Harvard Law School, Pepperdine University School of Law, Strauss Institute for Dispute Resolution, Chartered Institute of Arbitrators, and Columbia Law School. For more information about her practice, you can visit the website www.sambold-8law.com. She can also be reached at sambold@sambold-8law.com. So let's begin. Over to you, Ms. Sambold.
Thank you so much for the introduction. Well, I'm delighted to be here today. And just like, I'm sorry, your name, Avida, that's how you pronounce it?
Aviva.
Okay. How Aviva just introduced me. And here in California, and so here is 7:46 in the morning. We're just having a little trouble with the webinar jam, but thank goodness I was able to join. One of the things that I want to highlight about me is that I really passionate about, and not only about mediation and ADR, but about negotiation, and negotiation competitions is my thing. So in the last 15 years, I have served as a coach, as a judge. I haven't even organized negotiation competitions for the American Bar Association. I have participated as a judge and as a coach in the ICC International Mediation Competition, for the ODR International competition. I was lucky to be in Singapore and Dubai and in Paris, in many places, and all over the country, all over the United States, judging and coaching students in competitions like this. So let me first congratulate all of you to be willing to participate in this type of events. I think so you will grow personally and professionally as you go along during these competitions, and you will learn a lot about yourself, and you will refine your negotiation skills better than anyone else. This is a wonderful learning experience, so I congratulate you for that. So our agenda today. So this is what I'm gonna cover. In the beginning, I want to give you some pre-negotiation or pre-mediation preparation tips. Then some tips that you have to keep in mind during the negotiation. I'm gonna mention some common mistakes, some based on my experience as a coach, a mentor, and as a judge of these competitions. And I'm gonna provide some final takeaways. So my first tip, obviously, is prepare. If you don't prepare, just prepare to fail. And that, I think, applies to not only to these type of competitions, but to everything in life. As an attorney, you always had to prepare for a meeting, prepare for a trial, prepare for a negotiation, prepare for everything. And that's the key of success. So just start with preparation. And I wanted just to give you a disclaimer or warning. There's no single way there's no single formula to negotiate or to prepare. Because to negotiate effectively, you had to be flexible. You had to adapt. Every case is going to bring you different facts, different personalities, different styles, and new challenges. So you had to be able to adapt and change. So there's no single formula that you can take that you say, this is what I have to do every time that I have to negotiate, because that's not going to work. There's some guidelines and some tips, general tips, but in general, you have to be able to adapt to every single case. So Part of the negotiation preparation, the first level of preparing yourself for a negotiation is have a deep understanding of the case. I would recommend just to read those general facts, those confidential facts, not once, not twice, but at least 3 times. And once you read it 3 times, you have a really good understanding of the main facts, the law, what are your client's goals, what are your client's interests, what are the underlying interests of your client on the other side. Maybe you can anticipate those. And you can identify what are the problems, what are the issues, what are the positions, or what are the interests. And this is really important for you to identify. I have seen many times that students in competitions are really confused, and especially in the negotiation plans, when they identify the interests and the issues, they are very confused about these concepts. So it is super important that you know and identify and understand the difference between the 3 of them. So the issue is, what are the problems? What are the concerns that you need the other side to agree? And the position is what your demand is, what your client is demanding, what is he asking? And the underlying interest is what is behind that demand, behind that request that your client is making. Because behind every single demand or behind every single position is an underlying interest that your client has. And let me give you an example. And let's think about a breach of contract case. Your client is being sued because the plaintiff is claiming that you breached a contract and you didn't deliver the goods. So they want the money back. So that is basically the main issue, right? The position is he's claiming and he's asking for the money back, and he's asking for a payment of $50,000. The underlying interest can be in the confidential facts, or they can say that he's in a really he's really struggling financially, and he really needs the money because his daughter is seriously ill or something. And every case is going to be different, but you had to identify and you had to be sure that you know the difference between these 3 topics. They're normally included in the negotiation plans of every negotiation competition, so be sure that you identify those clearly. The second level of the pre-negotiation preparation is understand your bargaining range and understand the numbers, because what I have seen in many competitions is that we as lawyers and law students, we try to avoid anything related to numbers and calculating and trying to get the percentage of this number and trying to just calculate numbers. So be sure that you understand the numbers and calculate everything, calculate different options. But the more important thing is that you establish and understand the bargaining range that you have. Your client or your case, the confidentials probably give you the target price and the reservation point. The reservation point is mainly the bottom line that your client is willing to take. In my case that I gave you, maybe the plaintiff is asking for $50,000, but he's willing to take 25. That is not disclosed in the general facts, but that is in his confidential facts. And during the negotiation, that's what you have to keep in mind. So you have the bargaining range between 50,000 because that's what you're asking, and your reservation point or the bottom line is 25 because that's what your client told you in confidence that he's willing to take. So between those numbers, that's your bargaining range. So that's what you can work with during the negotiation. And that can determine what opening demand you're going to make to in the beginning of the negotiation, and how you can explain the rationale behind that opening demand. When you explain or give a reason or a rationale for your demand or for your opening demand, is more likely that the other side will understand what you're asking for. So be ready to justify what are you asking for. Be sure that you understand the bargaining range. Be sure that you don't go above or you don't go below what your reservation point is. Another good point is understand your BADNA and your WADNA, and understand the other side's BADNA and WADNA. And those are items that are normally included in the negotiation plan. And these are negotiation concepts that are sometimes very a little bit difficult to understand. But let me give you an example. And let's talk about BADNA. Let's talk about an employment offer. You are a new lawyer, you're graduating from law school, and you are negotiating your salary with a law firm that is trying to hire you. So in this case, if you have another option or you have another offer for a second law firm, your BADNA, your best alternative to a negotiated agreement, will be that if you don't reach an agreement with the first law firm for $25,000 salary, you have a second option. You have a second law firm that is offering you $20,000. That is your best alternative in case that you don't reach an agreement with the first law firm. That is your BADNA. Let's talk about WADNA. Well, the WADNA, in this case, if you don't reach an agreement with law firm 1 and you don't have a second offer, you don't have the worst alternative in case you don't reach an agreement is you don't get a job. So that is really important to determine and it's really important to understand before you enter into the negotiation. And like I said, it's normally included in the negotiation plan. So you have to really think about it and really understand it and really understand your BADNA. That will give you confidence in the negotiation, and you know that you have a good BADNA or you don't have a good alternative if you don't reach an agreement in the present negotiation. So, just think about it. If you don't have a second offer for a job from a second law firm, and you know that the only alternative that you have, the only job that you have is what law firm number 1 is offering you, you better negotiate, and when you go up the negotiation with the mindset that you have to reach an agreement because you don't have another option. So that helps you, and that puts you in the right mindset into the negotiation, the BADNA and the WADNA. At the same time, you have to understand or anticipate what is the other side's BADNA and WADNA. So you have to go through the same exercise and think about, what do you think the other side's BADNA is? What do you think the worst alternative to a negotiated agreement is for the other side? Talk to your teammate, discuss, and trying to anticipate what it can be. In that way, you can use that during the negotiation. The third level of preparation before the negotiation is to carefully strategize a general negotiation approach. So, and I'm talking here about aiming for a win-win situation and identifying opportunities that expand the pie for everyone. So I think that's one of the keys in the negotiation, and I'm going to repeat that over and over again. Always, and I think good negotiators advocate for the client's interest because that's what you have to do. That's what you hire to do in real life. A client hires you to negotiate on their behalf to get something for them, right? But at the same time, a good negotiator, and this, especially in these negotiation competitions, what the judges are looking for is that you have to obviously find out what are the other side's underlying interests and trying to offer options that satisfies the other side's client's interest too. Because remember, the other side has exactly the same job that you have. They had to advocate and they had to negotiate for their client. And they're coming into the negotiation table thinking about how they can get for their client, how they satisfy their client's needs. So you have to anticipate and you have to design a strategy, a negotiation strategy that includes not only options that satisfies your client's interest, but the other side's interest too. And make it hard for them to say no to your offers and options. So think about in a collaborative way. Think about win-win for both sides. That's when a negotiation deal is reached. Another good tip is a good way to start your negotiation strategy design is ask yourself, what is the best outcome that I can get given the conditions or the circumstances in this present case? And then work backwards to the ultimate question, how can that outcome be achieved given the circumstances? And that is another good tip that you can ask yourself to try to design the strategy. These are principles from a book that I really love. I have it here. It's Getting to Yes. This is, to me, the Bible of negotiation, and I always love that. And I love that book is because in the 80s when it was published, and I really recommend it to everyone to read it, is in the 80s when it was published, or before that, the idea that people had about negotiation was that you have to go to battle. It's an adversarial process where you go and fight, and this book changed that. From the book philosophy of the main philosophy is that when you go to negotiate, you don't have to think about it as an adversarial thing, as something that is unpleasant. You have to think about as something where we're gonna sit together with the other side and we're gonna try to figure out how to resolve this problem that we have in front of us. When you have that right mindset, it changed totally the whole dynamics of the negotiation. Think about your the other side of your counterpart as somebody that is going to sit down with you and is going to try to figure out how to resolve this problem. So one of the principles of this book, and I love that, and a die-hard fan of this principle, is that you have to separate the people from the problem. You have to be hard on the problem, but soft on the people. And that means that you have to attack the problem as a challenge, as an issue that you both have in common. You both have something that you have to resolve. Let's try to figure this out. Let's have to try to work together and try to figure this out. And concentrate on interest, not on the demands, on positions. So you have to be curious. You have to ask. You have to gather information enough to find out what are the other side's interests and trying to find ways and options to satisfy not only your clients, but the opposing side interests. And look for mutual gain. What else? Well, part of the pre-negotiation preparation is sitting down with your teammate and be sure you divide and allocate responsibilities. Normally, one is the client. Normally, one is the lawyer. So just be sure that you divide and allocate what each of you is going to do. So to gather information, be sure that you prepare some insightful questions. I always ask my students in the negotiation plan that I ask them to do is to come out with 10 insightful questions before the negotiation. And in that way, they're prepared to gather information. They have some questions in mind that they can ask and plan the answers to those anticipated questions because you don't want to be taken by surprise. And in the heat of the moment, too many things can happen. So it's always good to prepare and have something ready. Think about some potential and creative options and think outside the box. The best negotiators I have seen, they're students that came out with like a really out of the box solutions in the middle of the negotiation, and they really blew my mind. And so think about it. Think about that before the negotiation and develop a good plan B, plan C, plan D. Think about all the worst alternatives and the worst scenarios that can happen. And I remember as a coach telling my students, remember, this is your reservation point or your bottom line. And this is what are you asking for? So think about all the options in between and can be the worst thing that can happen in between those 2 points, keeping in mind your bargaining range. Another important point is really read and fully understand the competition rules. I'm glad that Sasha already went through all the competition rules, but if you take a look at them and really go through all of them, I think so it would be really helpful. I remember seeing in a competition recently that it was online, that a student was talking to somebody in his room, and one of the rules didn't allow the students to have anyone in the room during the negotiation. He didn't know that, and so he got disqualified from the competition. So that's what it is important to really, really know the rules, because you will be surprised. And there are many rules out there that they can disqualify you if you don't know them. Another tip that I want to give you is watch other competitions. There's so many competitions out there and online. Just find them, Google them, find them, and watch those competitions. To me is something that is really helpful to see how other people, and normally the teams that won different competitions, they're posting their videos online. So they're people that really they were really successful, and so it's really interesting to learn and see how they do it. Prepare a good negotiation plan. In every competition, and I think so for any type of negotiation in real life, you should have and you should prepare a good negotiation plan. And in this negotiation plan, the requirements, they always change according to the rules of the competition. So you have to look at the competition rules, and you have to see what are they requiring from you to include in your negotiation plan. Be sure to follow the instructions. And is a judge get really annoying when they get a negotiation plan and when they say no maximum 2 pages and the negotiation plan is 4 pages. That is already a bad start. So please be sure to follow the instructions from the competition rules. Every competition has different rules about the negotiation plan and about what you should include in the negotiation plan. But this is in general what I have seen and what I require from my students to include in the negotiation plan is, first of all, just identify the parties. Be sure that you know who every person and every company or every entity that is involved in the negotiation. Be sure that you know who is involved in the whole negotiation, and be sure that you identify, you know who they are. Identify, like I said, your client's underlying interest. That is super, super important. And on the other side, anticipate the other side's underlying interest. And the issues and positions is something additional that you can identify in the negotiation plan if it's required. Key questions, just anticipate some questions that you can ask to gather information during the negotiation. Be sure to explain what is the allocation of responsibilities with your teammate. You can explain the attorney will do the opening statement, and then the client will do whatever. But just be very concise too. That's another thing that I recommend. Because negotiation plans are normally given to the judges right before the negotiation, so we don't have too much time to read them. So really be concise, go to the point, and be sure that you don't like talk forever about the interests of my client or blah 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 and take forever to explain that. Go to the point. Don't throw everything in there that you think it can be. No, be really smart about what you need to include in that. And the judges are going to be more patient and be more, they're going to appreciate that you provide a good negotiation plan, and that is organized, is structured, and is concise. Remember, include your BATNA and WATNA. That's normally included in any negotiation plan. Your negotiation strategy and overall, some proposed solutions and potential agenda items. Another tip, or another of my recommendations, is especially in these international mediation or negotiation competitions, is learning about your counterpart. I think so. It's really important, and it's something that I always recommend. That to learn a little bit about who are you gonna negotiate with. And I do that in real life. Every time that I have a negotiation or a mediation, I try to learn a little bit about the people that I'm negotiating with, because it's gonna give you a little something to think about, and something to keep in mind. It's like, okay, this person is in this way, that they has intellectual property background, so, or you can, as personal injury with insurance, an expert, or blah blah blah. That kind of give you a little idea about this person. And these international competitions, it's important to learn too about where your counterpart or where the other team is coming from, and learn about their country and about their culture. I think so. Being negotiating with people from different countries is different, because you obviously everybody has different styles of communication, different styles of negotiation, and depending on where they come from. So there are little nuances that you have to keep in mind. So it's important to know a little bit about their country or their culture. Always establish rapport and trust with the other side. And I remember something that a student used to tell me, is that they used to draw a little, before every negotiation, they used to draw on top of their notes a smiley face, two smiley faces, and they used to believe that, okay, this is me and the counterpart at the end of the negotiation, celebrating that we reached an agreement. And that put her in the right mindset, that she needed to establish rapport and trust with the other side, that she was somebody that they're going to get along. Her goal was to get along with the other side as much that she was thinking about, at the end of the negotiation, we're going to be together celebrating because we have such a great time negotiating this case. And that put her in the right mindset. So that's something that I want you to keep in mind. Keep that in mind. Like, okay, two smiley faces, we're going to be celebrating and having fun. So develop some emotional competence. I'm a big fan of being an emotional competent negotiator, because I think emotions play a big part in any negotiation. As lawyers, sometimes we believe that we need to restrict and avoid any type of emotional part. But you know what? Any type of dispute, any type of negotiation always involves some emotions. And the emotions can be, and how you handle that can help you during the negotiation, or can be very detrimental. So I always recommend my students to read more about this book from Daniel Goleman about emotional intelligence, that I think is super important for any professional, any attorney, because you will be more aware about your own emotions and how to handle emotions from the other side, and how to be more competent to handle emotional situations. So please read Daniel Goleman's Emotional Intelligence book. It's a really good one, and a big fan of being emotional competent. I think so good and excellent negotiators are emotionally competent, highly emotionally competent. So part of that is empathy, part of the being emotional competence. And I think so empathy is such an important part of an effective advocacy and negotiation, because it reminds us to listen and to engage the person in their own terms, and engage and reminds you to feel in their shoes. Remember, a good negotiator is not only the one that advocates for their own client's interests, but the ones that trying to find ways to satisfy the other side's client's interest at the same time. That is the key. And I'm going to keep repeating that. because that is the main secret of a good negotiation. This is another interesting data that I think so. I always mention that too, because it's shocking to me, but it's something important that I want you to keep in mind when you're communicating, especially nowadays, this online setting. It's super important to keep in mind that 55% of communication is through facial expressions, and 25% is through inflection and tone of voice. And only 20% of communication is through the words that you said. So be really aware of your facial expressions and the tone of voice and inflection that you use, because that is 80% of how you communicate. Preparing the physical space. This is what I was mentioning in the beginning. Be sure that you, before the negotiation, be sure that you have everything around you, everything that you're going to need. I do a lot of webinars and a lot of mediations and arbitrations online. So I have my desk already ready and prepared. I have, you should see, I have food. This is coffee. I have water. I have my lights. I have my notepad. I have my pen. I have my microphone, my headphones. I have everything that I need around me. So it is really important to me, because every time that I have something, and it's pretty funny because today the webinar link didn't work for me. But it's good that you tried, and you, especially before, be sure that everything works, that you have a strong Wi-Fi, that you had a good video and audio. I remember participating in the ICC competition the last 2 years, or the last 3 years I've been online, 2 years, because of the pandemic. And I remember always somebody, and a student always had some type of problems with the Wi-Fi or with the video or with the audio. So it's important to try it and test it before your negotiation, before you participate in the competition, and be sure that everything works. And dress professionally. It's always important to have no, don't go crazy, don't go fancy. Just wear a nice solid colored shirt, and no big earrings, no makeup, nothing special. So just dress professionally, and at least from the waist up, for this type of mediation competitions and negotiation competitions. Practice and get feedback. This is one of the greatest ways to learn. Not only practicing, but getting feedback. So what I recommend my students, for example, is to sit down and negotiate with other team, practice, and record themselves and watch, so they can do some self-assessment or get feedback from somebody else if they don't have anyone else to get feedback. It is always super, super important, because you can practice as many times as you want, but if nobody's telling you that you're doing something that you don't notice that is not right, well, you're going to keep making the same mistake over and over again. So that is what is important, to get feedback and have somebody giving you some tips and recommendations. So the day of the negotiation. So who goes first? Well, normally in negotiation competitions or mediation competitions, the requesting party goes first and the responding party goes second. But that depends on every competition. So just find out what the competition is asking you to do. But in general, the negotiation process in general goes this way. First, opening statement of each side. Then when the parties start setting the agenda, then the negotiation starts, when parties start gathering information, asking questions, trying to figure out how, offering different options to resolve the case. And at the end, they reach an agreement or non-agreement. I remember when I was taking one of the negotiation or mediation programs in Harvard, how much time they spent talking about the importance of the first and the last 5 minutes of the negotiation. because the first 5 minutes is when you get a good impression, you give a good impression to the judges about so how you deliver your opening statements, how they confident and how articulate and how organized you are in your opening statement is going to make a big first impression. So really, really think about how important it is to give a good impression during the first 5 minutes, and try to finish too in a good way, because those last 5 minutes too are super important. So let's talk about opening statements. Those opening statements are normally the introductory remarks that each party have to make. But like I said, they set the tone for the whole negotiation. So be sure that you practice, that you have something in mind that you're going to say in the beginning and as opening statements. Give approach the other side, thank them for being there, give a little background about your case, think about how important it is for you and your client to be there and trying to work something out. I just set a good tone for the remaining of the negotiation, and deliver these opening statements with confidence. And remember, the confidence comes from being prepared. When you are not really fully prepared is when you start being nervous and start getting anxious. I think so the key to deliver something with confidence, and this applies to everything in life, is to prepare. And that's what I emphasize in being over-prepared. That will give you confidence. Remember, have a professional demeanor, be really respectful, be very collaborative, very nice and pleasant to with the other side. And a good opening statement is going to provide a good understanding about what are your client's interests, what are your objectives during the whole negotiation, and can foster a good problem-solving environment. That's what is important in a good opening statement. So let's talk about the opening statement for the client and the counsel. So for the client, because both of them have to give opening statements. So for the client, introduce yourself and your role as I am the CEO of this company. State in the past in a nutshell. Just give a brief background and state the intention, your interest, and what are you looking forward to accomplish with this negotiation. But remember, radiate a sense of collaboration. Be somebody that is positive, that is energetic. Don't start talking about, oh, we're going to litigate this case if we don't reach an agreement. No, that is not a good way to start. And end this statement with an overview of what is intended to achieve. So the opening statement for counsel. So just like the client, state your role here in the negotiation and emphasize the legal elements and legal aspects of the negotiation of the case. I explained that the interests and needs of your client. Just emphasize that you want to obviously what you want to accomplish during the negotiation, and end in a really nice and positive tone. So the importance of setting a good agenda. That is my next recommendation. A good agenda is something that you have to plan ahead of time too. Is the agenda is going to serve you as a roadmap for the negotiation. It helps you to structure the process. So it really is. It's like your security blanket. So developing and setting up a good agenda is super, super important. So be sure that you have a good one according to the issues and according to the needs of your client. And be sure that you use that in the beginning to serve you as roadmap for the negotiation. Normally, both sides are going to come up with their own agendas. So you have to work with the other side to design and create a mutual agenda that includes both sides' issues and points. And be sure to list every topic or issue in a really neutral way. And so, for example, you're not going to start the agenda with, let's talk about your breach of contract. No, let's talk about the contract. compliance, and don't blame anyone, trying to list everything in a very neutral way. During the negotiation, this is something that judges are normally gonna pay attention to. And let me show you, this is the folder that I have from all my competitions and all my notes and all the score sheets and everything that I have done in the last 10 or 15 years. This is what are the factors that the judges are looking for. They're looking for that you demonstrate a true understanding of the facts and the law, underlying interests, and general objectives. You don't imagine how many times I have seen students that are obviously confused, and I still, during the negotiation, is evident that they don't understand what's really the issue in the case. And when they don't have a good understanding of what's happening and what the case is about, what are the facts, and what are the underlying interests of the client, they won't be able to resolve it. And that is evident to the judges. So and that's what I say, be sure that you understand the case, be sure that you understand the facts, the law, the issues, and yours and the other side's underlying interests. Demonstrate flexibility and adapt to the unexpected. In every negotiation, you're going to have some challenges. So be sure that you are ready and you're going to be flexible to handle those, to handle any unexpected issues. Work well with your partner and allocate responsibilities. Be sure that the two of you are speaking and are participating and equally. Work well with your partner, because it's evident for the judges that if one of you is speaking most of the time and the other one is very quiet, that is bad and poor teamwork. So please be sure that you allocate and work well with your partner. In these negotiation and virtual negotiation competitions, sometimes they are allowed to use the whiteboard. In real physical competitions, you use a flip chart, but be sure that is allowed according to the rules, because that's another thing that I have seen students using that can be pretty helpful. But be sure that is allowed. Some competitions, they don't allow it. So during the negotiation too, be sure that ask the right questions. I have seen questions like, what is your bottom line? Well, they're not going to tell you that. So be sure that you ask relevant questions and questions that can help you, and questions that are more probably they're going to answer. And be strategic about what you're going to disclose and what you're going to keep confidential. I have seen too that many times that students have really good facts in the confidential, and they don't really use them during the negotiation because they're afraid to disclose them, when they can be really beneficial for their case. So be sure that you have a good grasp of what are the facts that you can disclose and what are they not. Like I said, always establish rapport, trust, problem-solving relationship with the other side. A good way to do it is demonstrate active listening and reframing what the other party is saying. So using words or expressions as, I heard you saying, or the interest that I hear from you is this, is this word agreeable to you both? Or is this way, is this okay with you? I see a lot of things that are complementary and trying to be positive, try to emphasize in what the other one's saying, and repeating what they're saying is sometimes helpful. The people really feel like they're being listened to. During the negotiation too, always keep in mind that, like I said, that you have to advance your client's interest, but you have to understand and acknowledge the other side's interest. Because remember, nobody's going to agree to something that is unfair to them. And the fairness concept is so important in negotiation, because if the people don't feel fairly treated, or the offers that you're making are not fair, they're going to be reluctant to accept those terms. and those offers. So highlight how your offer meets their client's interest, and when asking for a concession, have always a strong explanation of to justify the ask. Always have an objective criteria and say, look, I'm asking for this because according to the situation that we are right now, it is important to my client, it's important to our clients that we keep our business relationship. And so that's why I'm recommending, and that's why I'm offering this. So always provide a solid reasoning for any request or concession that you're making. And remember, a successful agreement is the one that meets or exceeds not only your client's interest, but the interest of both clients. That's when people reach an agreement. Common mistakes that I have noticed and through all my negotiation and mediation competitions. Well, the first is battle of the agendas. I have seen sometimes the students spending so much time fighting over, no, and this is my agenda, and the other side saying, no, this is my agenda. Oh no, I want this issue I want to talk about this issue first. No, I want this issue to talk about. And they spend so much time talking and fighting over whose agenda is going to be prevailing. So be aware of that. Be aware that time is running, and you have to, if your agenda it doesn't work for them, so ask them, so what will work for you? What are the first issues that you want to talk about? And that's going to tell you something about if they emphasize or they insist on talking about an issue first. So, well, maybe is this issue so important to them that it's better to go along with what are they asking for. So be flexible, adapt yourself to it, and don't spend too much time fighting over the agendas. It's just an agenda. Another mistake I have seen is reluctance to talk about money. And in many cases, obviously, they have 3 or 4 issues. And they put the money at the end. And in the last 5 minutes, they're trying to figure out the amount of money that it had to be paid. And obviously, they don't reach an agreement because they didn't talk about money and they didn't give themselves enough time to talk about the money. So don't be afraid to talk about money. If that is the main issue in your case, if this is a breach of contract where the plaintiff is asking for this specific amount of money, and that is the main topic, the main issue, please talk about that first. And if the other side is reluctant to talk, just emphasize that, make them realize, look, we have to talk about this because we're running out of time, and make them realize. And that takes me to my next mistake. That is not keeping track of the time. And that happens a lot. I see so many students just getting caught up in the opening statements. They make it too long, or they start fighting over the agendas, or they get hung up on one issue, one topic, and they go back and forth and how they want to resolve one issue, and they're not keeping track of the time. So please have a big clock right next to you, a big timer or something that tells you and keep reminding everyone, and be sure that everybody's aware, and that you have 20 minutes remaining, you have 5 minutes remaining, and don't be taken by surprise, like when you finish the negotiation and you weren't aware. So be sure to keep track of the time. This is another mistake I have seen, that is not summarizing at the end of the negotiation where were the terms that they were agreed. And I see a lot of confusion. I remember these students at the end of one negotiation, they have to do some self-reflection in front of the judges. And every student, every team has a totally different version of what was agreed. So it is important that at the end, you confirm with the other side. So remember, give yourself enough time to get to cover every issue and be sure that you have, those are the terms that were agreed. The poor teamwork, and I was mentioning that before. Be sure that your teammate is equally participating in the negotiation. I have seen many times students, teams where one of them is really strong and he keeps talking and talking and talking, and the other one is very quiet. That is a bad thing, because the judges are noticing that. So you be sure that the two of you are in sync, that the two of you are communicating, the two of you are participating in the negotiation equally, because the judges are noticing that. Another mistake I have seen is students that are sometimes too aggressive or too nice. And remember, there is no single formula to negotiate effectively. So I can tell you, oh, you have to always be collaborative and super nice and super polite. No, sometimes I have seen students that are really aggressive. So, and so obviously the way to is not to respond aggressively, but being a strong advocate for your client. If the other side is being too aggressive and you're too nice, they're gonna run over you, and the negotiation is gonna be affected because of that. So be sure to have a good balance with a strong advocacy, but be sure that you're not too aggressive and not too nice. The final takeaways, well, be prepared, practice, understand your why. And this is something that I recommend not only for competitions, but in life. Understand what are you doing, what you're doing. You are, and this is the big thing, this is a philosophical thing. What are you participating in this competition? What are you participating in this negotiation? And when you ask your why, that helps you. That just puts you in the right mindset. And you're going to take things and you're going to negotiate in a different way. Be a good listener. Good listening skills and active listening establish rapport and trust with the other side. Remember, active listening is not about just listening. It's about paraphrasing and repeating what the other one is saying to be sure that they feel like you are listening to them. Know your plan and know your strategy, but be able to adapt, because in negotiation, everything can be everything is dynamic and changes all the time. And just always keep a good balance between advancing your client's interest but being collaborative. Be aware of cross-cultural negotiation nuances, especially in these international negotiation competitions. And another thing I want to mention too is, remember, many students, for many students, English is their second language, but English is the language of the competition. So for those students that when English is your second language, be sure that you articulate every word. Be sure that you have a good vocabulary. You practice the words that you're going to mention. Practice your opening statements. Be sure that you are calm and relax, and don't speed up, because what I have seen is that the students are speaking really fast, and obviously nobody understands what they're saying. So that is always really good to be aware that, okay, I'm gonna be speaking. I'm gonna articulate every word. Choose your words right. You can pronounce this word. Find another one that you can pronounce. Practice and be sure that you have it ready to go. And that way, during the negotiation, you are fluent and you can be confident. Always keep in mind the big picture. Don't lose sight of your client's interests and the needs on the other sides. Remember, a good, successful and successful negotiator is the one that satisfies not only their client's interest, but the other side's interest too. That is a successful agreement. We do not learn from experience. We learn from reflecting on an experience and from getting feedback. Be creative. Think outside the box. No problem can be solved in the same way that it was created. I love this phrase from Albert Einstein. Always have fun. Always be positive. Always have that mindset. And so with that said, I'm ready to take any questions.
Professor Sambold, thank you very much for such an inspiring, vibrant and fruitful session. I'm sure our audience has learned so much from you today and from Ms. Matar as well. Now let's take some questions from participants. I have one question in particular as to how to set up agendas in negotiation procedure.
Well, and that's what you have to go first. Read your case, read the confidential facts, be sure that to understand and pull the what are the main issues, what are the main needs and interests of your client, anticipate the other side's interests and needs, and according to that, you're going to establish and you're going to design your agenda. But the key is to have a really good understanding of what's happening. What are the problems that we had to solve in this negotiation? And according to that, say, look, we had to talk about the contract. We had the contract compliance. We had to talk about the delivery of these goods. We had to talk about the business relationship, and just list those according to what you understand the problem or the case is about.
Thank you very much. But yes, we have a query about elaborating this a little bit more from Garima.
Garima?
Yes, like how do we negotiate a competition where we have no provision of confidential information? And the second question is, how do we anticipate the interests of the other side when the GI does not give out any hints on it?
Well, that's what you have to anticipate. And obviously, no negotiation competition is going to provide you the confidentials from the other side. And that happens in real life too. There's always going to be information that you don't know from the other side that they're going to bring during the negotiation. And that's why you have to kind of anticipate a little bit and guess and think about what they can be, that information, or they can be those goals or needs from the other side according to the general facts, and just anticipate some things. But having a good understanding of the case is going to help you to figure that out and anticipate it and guess right what it is.
Thank you. Actually, the elaboration part was about the roles. We had a question about the roles. Can you explain about the roles a little bit more?
The roles, the rules.
It's about the roles. Who will talk first, and how should they divide the roles?
Oh, okay. So, well, that is in every competition, they are normally a client and the attorney. So obviously, the client and the attorney, they have specific roles. The lawyer is going to emphasize more on the legal aspects of the case, and the client is going to talk more about what is important to him, how hurt he was because of what happened. Oh, he's going to talk more about his feelings. He's going to talk more about his needs, about his interests. So that's kind of the general difference in between the two roles. But every case is going to be different. Every case is going to have different facts, and they're going to give different roles to each of them. And so just be sure that you understand what are the roles and where the scripts. This is like in a movie where they give you a script and say you are going to be the client and you're going to be the attorney, right? And you're going to have to read what is the script and what exactly you have to do in order to perform during the negotiation or during the movie, and just get into your role according to that script, according to the facts that they're giving you. That's going to give you the instructions of how or what is going to be your role, what you have to say, and just get into it, get into the role. It's like you are the CEO of a company and they breach this contract and you're suing them and you're really struggling financially. Get really into the role. Explain like look, my company is really struggling. This has been really hard on me and my family and on my business. Really get into it. If they're telling you that that's your role, really get into it. Just be sure that you follow the instructions, follow the facts, and understand them.
Right. We will just have a few more questions because the session has been running far too long. I was warned. So who will set the agenda, counsel or the client?
The two of them had to work together before the negotiation. That's part of the preparation before the negotiation. The two of them had to sit down and work together to design that agenda, to decide how they're gonna develop the issues to talk about, the two of them.
Thank you. And the next question is, thanks for the session, ma'am. Ma'am, you mentioned something about cultural differences. Since we are not allowed to disclose names or countries, how can we identify these differences?
Well, and normally in the competitions, I can see that we can see the students, where they're from. I have seen that as a judge. I don't know as a student, but I can see, we don't see the names of the students. We don't see the name of the school, but we can see the country where they come from. At least as a judge, I can see that. And I think that gives you a little idea of like, oh, I'm going to be competing against somebody from the Netherlands or somebody from India or somebody from something. And in that way, you can get a little idea about who are you negotiating with. And I think so that's always helpful to have that, to develop some cultural sensitivity and cultural competence.
Thank you. So greetings, ma'am. How do we communicate our disagreements to the other party without sounding aggressive?
Well, I would say that always remember, anticipate what are the other side's interests. What do they want? And offer and make your requests or offers according to that, make the offers in such a way that they can say no because they satisfy their client's interest. Remember, the other side, they're doing exactly the same thing that you are. They're advocating for the client. They have a goal in mind. They have an objective in mind. They have an underlying interest that they had to satisfy. So it's just about finding out what are those interests that they have to satisfy. Your case, you know your side, but you have to anticipate and predict and understand how. That's what it is important to gather information, to ask the right questions, to be curious and to find out more about them. And according to that, you're going to craft different offers and different negotiation strategies to satisfy theirs and yours interests and come out to an agreement.
Thank you. And we have the final question. There are moments in a negotiation when the two parties have reached an absolute impasse and both are very adamant to maintain the stance. What will we do in such situation?
Well, I think so questions are the best tool to help you when things get heated and the negotiation is moving forward. Ask them. It's like, what would you like to do? Okay, so if this doesn't work, what else we can do about it? And everybody comes to the negotiation with the idea to reach an agreement. Everybody wants to reach an agreement. Everybody has the same mission. So the difference is how you get to you get to that final at the end of that tunnel, at the end of that, or how do you accomplish that? So asking them, ask questions, ask open-ended questions, and find out what exactly do they want. If they don't like this, what else do you like to do? What else can work for you? And find different ways that include them and ask questions.
Thank you very much, Professor Sambold. And before leaving, there is a special announcement from the Newcastle University, the UK. For those who have a particular interest in negotiation and mediation, a new online LLM program in mediation and international commercial dispute resolution is now running at Newcastle University. There is an online information session on the course on Wednesday, June the 29th at 4 p.m. the UK time, where we will showcase some of the course materials. So if you have an interest, please sign up to attend. The link and the details to register can be found in the chat chat box now. Please join in exactly at the designated time tomorrow to not face any issues. I'm sure you will all do exceptionally well, and all the very best to each and every one of you. Thank you.
Well, good luck, everyone, and so I wish you the best of luck.